Welcome to ThePrint. So the Karnataka High Court today came up with a very important verdict. It has upheld the hijab ban in government educational institutions in the state. And in doing so, it has answered, the judgment frames several legal questions as well, and it has answered all of them in a 129-page verdict. The High Court, a three-judge bench of the High Court led by the Chief Justice, has held that wearing of hijab is not a part of an essential religious practice in Islam, and therefore it has held that the government and these schools can impose reasonable restrictions, that banning the hijab within classrooms is a permissible restriction that the government and schools are within their power to do. Now in this special live, we will, Bhadra, my colleague Bhadra and I will be taking your questions on this judgment. So in case you have any sort of questions on what the court has said, what this verdict means, if you've heard about something that the judges have said but don't understand its meaning, do send us your questions and we will try our best to clarify it to you and explain it to you. Bhadra, the first question that we're getting is from Siddhant Kumar, actually. I'm glad we've already started getting questions. He's asking, what were the core arguments presented by both sides and what articles of the Constitution were mainly referred to? Maybe I can talk about the arguments, and since you, followed all the arguments in the court, you can go ahead.
Okay, so, Apoorva, as you mentioned, the judgment categorically rules that hijab is not part of the essential religious practice in Islamic law. So obviously the first point of argument that was raised by the petitioners was that wearing of hijab is integral part of Islamic practice, and it was on this premise that they went to the High Court. Apart from that, they had raised several other grounds as well, in the sense that they claimed, that this right is not reasonable, it is not a reasonable restriction, and that the college does not have the right to impose this sort of restriction, particularly because hijab wearing is essential to Islamic law. And then they further said that, the College Development Committee, which had actually prescribed the uniform system for the particular college, which was in Udupi, it is a pre-university college. So they claimed that these College Development Committee, which is headed by the MLA of that area, also is not empowered to lay down such kind of restrictions. Further, the petitioners claim that even the government, which issued an order on 5th February 2022, virtually extending its support to the ban, this order was also not constitutionally permissible. Now, the particular articles on which they had, on the basis of which they had moved these petitions were basically Article 19, which is right to free speech and expression, Article 21, right to privacy. In that, they were reading right to wear, whatever they wanted to, And then they went on to talk about Article 25, as we have pointed out initially, that their main argument was that hijab is part of their essential religious practice. So Article 25 permits Indian citizens to follow their rights and practice their faiths. So these were the crucial points of arguments that were raised in the High Court.
Absolutely. I hope, Siddhant, I hope that answers your question. Another question that we have coming is from Arvind Ramanujam, who's asking, what is the legal history, precedence of courts interpreting the term essential religious practice? So basically, the way this doctrine evolved, it evolved from the Supreme Court, but the Supreme Court has traced the origin of this doctrine to something Dr. Ambedkar said in the Constituent Assembly. You may agree with it, not agree with it, but that's how the Supreme Court evolved this entire doctrine. I'll read it out for you what Dr. Ambedkar said during the debates. He spoke about he said that the religious conception in this country are so vast that they cover every aspect of life from birth to death. There is nothing extraordinary in saying that we ought to strive hereafter to limit the definition of religion in such a manner that we shall not extend it beyond reliefs and such rituals as may be connected with ceremonials which are essentially religious. So what he was trying to say is that we won't extend this right of protection beyond reliefs and such rituals which are essentially religious. That's the phrase that he used, and that's this phrase that he used was the origin of this test, essential religious practice test. If I talk about one of the recent judgments that used it, it was the Sabrimala case. But just to give you a brief of how it evolved, how the test evolved or just to, in fact, before that, just to let you know briefly what this test entails, it basically says that Article 25, which guarantees the right to freedom of religion, would not protect all sorts of practices within a religion because it is subject to various things. It is subject to public order, health, morality, and other articles of the constitution as other fundamental rights as well. I'm sorry. So within that sphere, the courts have held that it will only protect practices that are essential to a religion.
Basically, something which is fundamental.
Yeah, that
fundamental
is so
to the religion.
That if you don't protect it, the religion itself will fall.
Yeah.
Loosely from what courts have said. Now, in the Sabrimala case, especially Dr. D.Y. Chandrachud's opinion added another thing to it, that if you have come to the court to demand that a practice should be declared as an essential religious practice, you don't have to just show that it is essential to that religion. You also have to show that the practice conforms with the fundamentals of the constitution and constitutional morality. That is the morality that the constitution talks about. Yeah. So these are the sort of tests that courts have come up with over the years, and that's how it's evolved.
So basically, I think, Apoorva, when this is exactly what has been also held in this particular judgment, that when you talk about essential religious practice and taking cue from the Sabrimala judgment itself, what the Karnataka High Court has ruled is that essential means it has to be fundamental, means it should either date to the time when the religion actually started or predate. And it should not be recommendatory in nature, but it has to be obligatory. An obligation means that if you do not follow that particular practice, either you are treated as an outcast or there is a punishment which you are liable to suffer. So these are certain principles that have been laid down, and as pointed out by Apoorva, after the Sabrimala judgment, yet another principle which has come is, because this is something like an evolution of the law, the provision, and yet another test which actually got introduced after the Sabrimala judgment was that this practice should be associated with the constitutional norms, which Apoorva has pointed out.
In fact, the test that Bhadra just pointed out, a test that the court spoke about with regard to essential religious practice, that's what the Karnataka High Court, considered and applied in this case to rule that it referred to various verses of the Quran to rule that the Quran does not mandate wearing of a hijab. In fact, the Quran does not use the word hijab as well. And with regard to the commentary, when it looked into that, it said that since it does not seem obligatory, there's no, like you mentioned, punishment if you don't wear it. Therefore, since it's not obligatory, it is not a part of an essential religious practice.
In fact, it has discussed at length, in detail, about why hijab was being, it was allowed. The reason was that it was basically a laudatory move, that if women are stepping out of the house, so they should just cover themselves, because the instances of molestations and women harassment were quite high in the Middle East countries at that point of time. Yes. At that point of time. So it was basically to protect the women. But as pointed out by the High Court, the time has progressed, and now circumstances have changed. So the basic idea behind hijab is definitely not what the petitioners had showed up to, or they tried to point out in the High Court.
Another question is coming from Aditya, who's asking how many petitions were filed for this in Karnataka High Court, and has a similar petition been filed in any other court?
So there is, there were multiple petitions filed. Along with multiple petitions, there were several applications that were filed in the Karnataka High Court. But Karnataka High Court restricted the hearing only to 4 petitioners. And with regard to the other applicants, it just allowed them to file their written submissions. So, they had to kind of really restrict and limit the hearing, because the entire hearing in the case continued for 11 days, and extensive arguments were advanced on behalf of the petitioners as well as the state government and the college and the college development committee, which actually prescribed this uniform. So since it was really, dragging and carrying on, so the High Court was very categorical and it restricted the hearing only to 4 petitioners. And another reason was because if you recollect, Apoorva, there was an interim order that was given by the Karnataka High Court. So it felt, that instead of dragging the interim order, let us just conclude the hearing and then deliver a final verdict. So main petitioners were 4, but there were multiple applications that were filed.
Just a reminder here, please do send us your questions on anything around this verdict, around the hearings that went on consecutively for quite a few days, around the arguments that were made, around the judgment. If there's something about the judgment that you want to know more about or need an explanation on, do not hesitate and send us your questions, and we'll make sure that we take as many of these questions as possible.
So there's Aditya's second question. I will just respond to that also. Whether there are similar petitions filed in other courts? No, no such petition is pending in any other court, since the issue escalated and it triggered into a law only in Karnataka. But yes, there is a petition pending in the Supreme Court that was filed immediately after the interim order was pronounced by the Karnataka High Court. But the Supreme Court bench, led by Chief Justice of India, had at that time declined to entertain the petition, and it actually said that it would like to wait for the Karnataka High Court to deliver a verdict on it. And it also cautioned the petitioners not to unnecessarily, nationalize the whole issue. So now we will just wait and see whether that particular petition gets revived or whether the petitioners will file a fresh appeal against the Karnataka High Court verdict.
In fact, there's a related question coming in from Abhishek Mukherjee, who's asking, what if the petitioners go to the Supreme Court and what next if it is not settled there? Abhishek, there's always, of course, a possibility that the petitioners might go to the Supreme Court to challenge this verdict. Like Bhadra mentioned, there's already a petition pending challenging the interim order. So if these petitioners also approach the Supreme Court, most likely then it'll get clubbed. The court will hear it together. As for if it's not settled there, of course, the court will hear it. This will depend on what you mean by settled, but the court will, of course, hear the cases, the petitioners again and the respondents.
No, of course, I don't see the issue settling down, so soon, because I think there will be another round of litigation in the Supreme Court, especially because, a constitutional question has been raised in this issue, which was, elaborately discussed in the High Court. So I think the petitioners will definitely come to the Supreme Court, and it will be yet another long hearing in the matter. So that is the thing. Apoorva, I would just like to point out another interesting aspect of the judgment, and that is with regard to the fact that, how the judges have actually commented on, some unseen hands that are at work. Because according to the judges, Udupi, where this pre-university college is located and, where the entire controversy began, they say that, this dress code has been there in this particular pre-university college since 2004. And, they also go on to say that they are impressed that even Muslims over the years have participated in the festivals that are celebrated in Udupi. And they kind of, in a way, I think they accepted the contention raised by the college that this entire thing was a motivated, thing, and that there was no such controversy with regard to uniform prescription. So I think, of course, this argument and this observation is coming at the fag end of the judgment, but the fact that they have mentioned about this, that there is an unseen hand, it actually, in a way, supports what the state and what the college had actually advanced, in the court, in their argument that the PFI, which is supposed to be the, a radical organization, is the one that spearheaded the entire campaign and motivated and instigated the students of the pre-university college to kind of, protest against this so-called circular. So now what is to be really seen is that how the state really carries forward this, because the state police is actually investigating. They are carrying on this probe, but I think the High Court has not sought any status report on this. If I'm
No, it has just mentioned the probe at the end, that of course there's a police probe going on into this, but the court has in passing just mentioned that that's what it felt about the whole thing.
Apoorva, will you be able to kind of tell us about what the court has actually spoken with regard to the uniform prescription? Because they say that it is a constitutionally permissible restriction. So do you think, what exactly have they said with regard to the school's power to actually have a uniform code for the students, because they have gone to the extent of saying that this kind of a regulation is universal. It's religiously, it is neutral. So if you could just tell, for our viewers, if you could just explain a little bit briefly as to what they have pointed out or ruled or concluded.
Of course, Bhadra. So now this entire reasoning that the court has given just on the aspect of uniform is a little layered. The court has spoken about how firstly the government, because a government order was under challenge, 5th February government order which spoke about CDCs allowing and permitting uniform that does not violate public order, and there were several things said in that order. So now the court looked into that and said that the government definitely has statutory power to issue such an order. This was under the Karnataka State Education Act. Now then it goes on to the school's power to prescribe this uniform, and the court says that of course the schools have this power. It said something on the lines of it can't imagine a school without a uniform, and of course I'm not quoting the
exactly
verbatim,
right.
But that's what it said on those lines. And then it went on to talk about how it ensures uniformity within a classroom, saying that such uniformity. So there was another argument, just to let you know, the petitioners had also argued reasonably so that the petitioner should be allowed to wear a matching headscarf maybe with the school uniform. They will still wear the uniform, but with that they'll wear a matching headscarf or a hijab. The court opined that when that happens, it will create two different categories of female students, and that would still not ensure uniformity. There's another third commentary also. First there was the government's powers, then the school's powers, then a third commentary on collective rights and individual rights as well. And the court, this was in the context of talking about their right to dress the way they want to dress and their right to privacy. And in that context, also the court said that their individual rights will have to give in when it comes to schools and the school's powers to prescribe a uniform to maintain uniformity in a classroom. And uniformity in all sense, that's what the court said, to sort of exclude or bar any sort of religious symbols within a classroom.
In fact, they go on to say that no reasonable mind can imagine a school without uniform. So what they actually meant by saying this is that if you do not have a uniform system in school, it can breed in indiscipline, and not just in the school, but later somewhere in the society. So that is the reason why they held that prescribing a uniform is a constitutionally permissible, reasonable restriction. I think if I'm correct. So we have another question, Apoorva, which is from Amartya Ray. He says, if this matter is appealed, will the parties be allowed to furnish new evidence and fresh arguments? So I'm sure he's talking about if the parties are allowed to appeal in the Supreme Court.
Yes.
So, if you go by the strict procedure, no, it is not possible. Whatever questions and arguments were advanced in the High Court, the parties, the petitioners, as well as the respondents will have to restrict themselves only to those arguments. So no fresh evidence or no fresh arguments can be led in the Supreme Court if the parties decide to file an appeal.
Unless there's a fresh PIL, but that's another.
Yeah, but I don't think that a PIL will now lie,
Yeah,
since the
yeah.
matter has been
Heard by
adjudicated.
the High Court.
Yeah, and a ruling has been delivered. So the only available legal option to them is, is an appeal before the Supreme Court.
Right.
So, yeah.
All right. We'd also like to talk a little bit about essential religious practice again, the way court went into that and ruled that, and the repercussions of such a ruling as well. Because now I'm sure you must have read news articles before on pointing out both sides of the debate on this point, where a few high courts had earlier spoken about a little bit about whether wearing of the hijab is an essential religious practice or not. But if you see those judgments, whether they're Kerala High Court judgment, there was a
Or Bombay,
CBSE ruling judgment,
and a Bombay High Court
Bombay
judgment
High
as
Court
well.
judgment.
Yes.
But if you see those and this, you will see that this is actually, why this is significant, because this is probably the first authoritative ruling on this point of law, whether wearing of hijab is an essential religious practice or not. And with how the law has evolved, as I mentioned earlier, this will have a bearing on the protection that is granted to then when it comes to wearing of the hijab in other spheres as well, because the moment a court rules that it is not essential religious practice, there are curbs that can be imposed, there are bars that can be imposed. So that way as well, this is a significant ruling. Of course, again, it's a 3-judge bench high court ruling, so there could always be a full court high court ruling from another high court that comes up all over the country. There could be conflicting rulings as well. So finally, it is the Supreme Court which will have to settle the issue in any case, whether these petitioners appeal to the court or don't appeal to the court. But the final this thing will, of course, lie. In case you're wondering if another high court also takes it up, if it's a 3-judge bench in that high court as well, this judgment will definitely have persuasive value. That bench does not have to adhere to this judgment as precedent, but it will have some sort of persuasive value.
In fact, this 3-judge bench of the Kerala High Court strictly did not go by an earlier judgment of the Kerala High Court itself that allowed a girl to wear a hijab and take her medical entrance test, if I recollect it correctly. So while referring to that particular verdict, what this bench has actually said is that even that bench had in passing observed that different courts can have different views with regard to this practice, but the specifics of that case and this case are very different. They somehow they are not at all similar, and that is the reason why this particular bench of 3 judges gave a divergent view, gave a completely different view, from the view taken earlier by the other High Court bench of Kerala.
I think if you go through those judgments as well, there isn't this detailed reasoning as well somewhere or the other. I feel like because this was also it became the issue did blow out and come on the national stage, and there were detailed arguments made from the side of a lot of petitioners. So I don't think those judgments were as detailed as well on this specific point of law. So this does seem like a very authoritative pronouncement.
It is. And I think for another reason, Apoorva, because probably for the first time, this issue of the constitutionality of this entire issue was raised in the court, in the High Court. So that is why it is definitely an first authoritative judgment. Yeah.
We'll take one last question. This is by Anirudh Mirmira, who's asking, is the ruling valid for all public and private workplaces which have uniforms or restricted only to schools? Anirudh, the ruling per se, it of course it raises constitutional questions, but it also was restricted to the Karnataka State Education Act, the order issued under it. So for now, this part, like the ruling as a whole, does only apply to schools. Right,
yes,
Bhadra?
yes.
But the ruling on the constitutional part, on essential religious practices part, of course, is a general ruling.
Direction,
so that would still apply. So in case, let me further clarify it. So in case tomorrow, if in a public private workplace there is an order that's issued, probably under some other law which bans wearing of hijab, then if it goes to the court will look into that specific law, whether they had the power to issue such an order under that specific law, but it could still refer to this judgment on the aspect of essentiality of this practice under Islam and rule accordingly. So it won't exactly apply, but this constitutional interpretation, it definitely has a universal application, so to say.
I think what exactly will be tested is whether the restriction at a particular place, at that particular time, whether it is reasonable or not.
Yeah.
So that will be,
yeah,
that only that question will be tested. But as Apoorva points out, the aspect on whether it is constitutionally permissible or not, as in whether hijab wearing or ban on hijab, or whether hijab is an essential religious practice or not, as far as that aspect is concerned, this applies generally. But if there is an imposition or a ban, then whether that ban is a reasonable restriction or not, that will be the question that has to be decided by the particular court before which the issue will be raised.
Absolutely. And with this, we wrap up today's live. I hope you were satisfied with all our answers. If you still have questions, don't hesitate to ask them in the comment section, and Bhadra and I will try to go through them and answer as many as possible. Thank you.
Thank you so much.